beloved Prime Creator. We know we are beloved by our beloved because we dare to be free. We dare to express ourselves and to stand. We dare to stand in front of our enemy with the defiance, not compliance, for it is compliance that has got us here. The enemy uses our very nature against us. Where we have trust, there is deceit. Where we have vulnerability, there is manufactured fear. Where there is love, hate confronts. But therein lies the key. We remember who we are. We summon our higher self, our essence, our spirit, and can then recognize how very powerful we are. That love abides in all things so long as we tune into that awareness and hold it. For where there is trust in our fractal nature of Source, vulnerability is overcome. When those fears are conquered, we build trust in ourself and our inherent strength. When we come from that place of inner strength, we are able to see the needs of others and give support. When we are in our essence, we feel our inherent loving nature and realize we can not only overcome, but thrive beyond ordinary limitations. For none of us is ordinary. We are, after all, fractals, chip upon chip of the old original block that is our divine, beloved creator of all that is, ever was, and ever will be. Let it be so, and so it is.
Hello, my name's Ron Vroman. I have a script to read, and today I don't feel that I'm capable of reading it. I found a reader, and she'll read it for me now. I yield.
Ron Vroman was given 5 days in Marion County Jail by Cortland Geyer for contempt. He is filing for an award of $250,000, 18 U.S.C. 3571, as a guide. Cortland cannot support his claim of jurisdiction over me or that he has the proper credentials or legal and legitimate court. Hello, Shelley. Do you want an award from our Amendment 7 jury? Cortland was not in good behavior. I asked if he had seen my email from our court or something similar. He found me in contempt, and his staff refused to accept an immediate and lawful petition for mercy from 2 members of our assembly and court. An Amendment 1, and we are one Supreme Court claiming original jurisdiction, Article 7, Amendment 7, Article 3, Civilian Common Law Court of Record with ex parte mulligan implemented on Oregon. Without rebuttal for 8 years, on Oregon, the state. Contempt proceedings 33.015, definitions for ORS 33.015 to 33.155 for the purposes of ORS 33.015 to 33.155. 1. Confinement means custody or incarceration, whether actual or conservative. 2. Contempt of court means the following acts. Hello, Richard, et al. The hierarchy on the land and soil jurisdiction, men and women with our progeny on Oregon. The people on the Oregon Territory delineated the terms of their statehood and petitioned the United States for membership into our Confederation and Perpetual Union, styled the United States of America. The Congress assembled, agreed to statehood, and President Buchanan signed it February 1859. So we know it happened. We do not know the conditions of the contract. We do know returning to a constitutional Republican form of government is the goal. At that point, an actual move to remedy happens, abandoning de facto and causing jure to return. You must do it yourself. No one can do it for you. The Article 7 amended, he who can be deceived, let him, color of law. This has been hidden from us by the last 7 secretaries of state, 3 deputies that will not permit a viewing of our statehood document. It is a paradox. When you are smart enough to fill the office of sheriff and do it with honor, having actually read the Constitution and own Bouvier's Law Dictionary, 6th edition, 1856, available on Amazon, printed on Troutdale. We can change the fraud that should not be and correct this to remedy with peace, safety, and happiness for Oregonians. The people, persons are other jurisdiction de facto. People are jure. Jurisdiction has been claimed for probate and no evidence of proper court is available, and you are silent at quiet title. You have not presented your credentials to Charlie White. You have not supported your position. Rebecca, Kevin, Caprice seem to be in contempt of common law. They acquiesced and defaulted and are currently simulating a legal action. Claim: failure to provide the documentation supporting their claim to be lawful judges on Oregon is my claim. In my capacity as a man on Oregon, jura summa imperi. On November 2022, the judiciary on Oregon acquiesced and defaulted to being without proper documentation. Article 7 amended is de facto, and this is a fact established by the Oregon Statewide Jural Assembly, the Provisional Jure Court, Government, Article 1, Section 1, a social compact with Article 3, 1 Supreme Court, claiming original jurisdiction, Article 7, Amendment 7, Civilian Common Law Court of Record with ex parte mulligan implemented. Signed, sealed, stamped, witness, proof of service, published at www.orsja.org for 7 years. 3 Portland CTV half-hour weekly for 5 years, YouTube 5 years, Brighton 5 years, all without rebuttal. The claims: they are unlawful, Article 7 amended, judges de facto without supporting evidence. They are simulation of a legal action, ORS 162355. Cortland Geyer has accepted 2 claims of cognizance into his court and acquiesced and defaulted to both and persists without rebuttal to the claims he has not supported. There is no evidence that Article 7 amended is constitutional and that he has a valid oath and bond ability. There is preponderance of evidence that it and he are de facto, Black's Law 6 page 416, illegal of illegitimate. Rebecca Guptill, the de facto presiding judge on Washington County, has accepted a claim of cognizance and acquiesced and defaulted to no jurisdiction and persists in her de facto court against a man on Oregon. Washington County is unable to provide a proper judge for probate. SEC versus Jarsky 603 US 109 2024. The Fifth and SCOTUS agree Amendment 7 is required and Article 3 is recommended. Article 7 amended is in the Constitution and that these two took an oath to. They are color of law. Article 7 amended violates Amendment 7.
I am Kim, one of the people, and I have a message for you. Where are our sheriffs? Our Article 3, Amendment 7, Civilian Common Law Court of Record has made numerous visits and relentless communications to our county sheriffs on Oregon. Why? Because our sheriffs are our first protection against government overreach. It is our county sheriffs that should be there to assist seniors to prevent their eviction from their homes and all they possess. It should be our county sheriffs who protect and defend the people from a corrupt court system rather than ticketing them or supporting the illegitimate amended Article 7 courts. Our sheriffs seem to be avoiding any engagement with us, the people reaching out for a conversation about their refusal to see us. Contact requests are met with cricket sounds. Where are our sheriffs? It is significant that they take a proper oath to the Constitution, circa 1859, with its original jurisdiction, that is, to the people, rather than to a corporation, to our Creator, that is, with God included. Such a dejuration, a solemn oath, is needed for there to be a remedy in our system of governance. Let's get this ball rolling. It just takes one of you to make a difference, to get it started, to assist in awakening your colleagues in serfdom. Let it be so. I yield.
This is a quiet title proceeding. We are in the office of the Sheriff of Washington County in the lobby, and we are conducting the quiet title hearing with our court of record. This is our marshal. We have on the table the quiet title instrument. We also have Bouvier's Law Dictionary, 6th edition, along with the United States of America's Constitution, circa 1859, and Oregon's Constitution, circa 1859. Please read.
Oregon Statewide Jural Assembly, www.orsja.org, cause number 02092026, quiet title R. Vrooman. Notification of quiet title and caveat to will. This is a notification of quiet title and a caveat to will and probate in open court regarding the property referred to as Lot 10, Brookview, more commonly known as 14725 Southwest Glenbrook Road, Beaverton, Oregon 97007. This property has been recorded in Washington County records under the name Vrooman Living Trust. Accompanying paperwork, which is included, explains the particular complication and clouding of said property. It should be noted that since the time of the purchase mortgage, the home has been occupied by Ronald Charles Vrooman and his wife Aida Cecilia Vrooman until her unexpected death in 2025. With the assumption that Ron would pass before Aida, Ron relinquished the property they purchased and their shared business to his wife, recently deceased, to do as she saw best and felt most secure. A claim of cognizance has been filed and a copy is included in this notification. It provides for a third-party intervener, a civilian common law court of record, to conduct the finalization of the quiet title. That court is an Article 3, one Supreme Court claiming original jurisdiction, Article 7, Amendment 7, Jural, civilian common law court of record, having implemented ex parte Milligan on Oregon. Oregon was established as common law state in 1859 and was the last to join the Union of the several states of the United States of America. Article 7 in Oregon's Constitution was amended fraudulently on November 8, 1910, and cannot therefore provide a proper framework for this proceeding. Our Jural, Civilian Common Law Court of Record, is providing such a required court to adjudicate the veracity of this quiet title claim with prejudice. SEC versus Jarkowski, 603 U.S. 109, 2024. The Four Corners Rule is in effect here as we are functioning in common law. Therefore, you are to utilize one of your three opportunities to respond or object to the completion of this contract. This will be read, delivered orally, and documents collected at 10 a.m. February 18th, 2026 at the Washington County Sheriff's Office Headquarters Building located at 2015 Southwest Adams Avenue, Hillsboro, Oregon 97123. Charlie White, Jural Court Administrator, signed February 7th, 2026. and CC to Ronald Charles Ruman, Washington County Recorder, Office of Washington County Sheriff, Freedom Mortgage Company, On Point Credit Union, Richard Mulmer, Trial Court Administrator, Judge Rebecca Guptill. This is a one-page instrument of an Article 1, Section 1. We do lawful, not legal, and this is our best effort. Cause number 02092026, quiet title RV.
Hi, I'm Eric Dover with the Oregon Statewide Journal Assembly, and I have some messages for the Oregon sheriffs. Where are sheriffs? Our Article 3, Amendment 7 Civilian Common Law Court of Record has made numerous visits and relentless communications to our county sheriffs on Oregon. Why? Because our sheriffs are our first protection against governance overreach. It is our county sheriffs that should be there to assist seniors to prevent their eviction from their home and all they possess. It should be our county sheriffs who protect and defend the people from a corrupt court system, rather than ticketing them or supporting the illegitimate amended Article 7 courts. Our sheriffs seem to be avoiding any engagement with us, the people reaching out for a conversation about their refusal to see us. Contact requests are met with cricket sounds. Where are sheriffs? It is significant that they take a proper oath to the Constitution, circa 1859, with its original jurisdiction, that is, to the people rather than to a corporation, to our Creator, that is, with God included. Such a dejuration, an oath, is needed for there to be remedy in our system of governance. Let's get this ball rolling. It just takes one of you to make a difference, to get it started, to assist in awakening your colleagues in sheriffdom. Let it be so.
This is a notice in demand from the Oregon Statewide Jural Assembly. Notice to principal is notice to the agent. Notice to the agent is notice to the principal. And the cause number is 0822-2025, notice defining terms. Jura summa imperii, page 701, volume 1, Bouvier's Law Dictionary, 6th edition, 1856. Sovereign, page 589, volume 2, Bouvier's Law Dictionary, 6th edition, 1856. In the United States, the sovereignty resides in the body of the people. We, you, and I, have the rights of sovereignty or supreme dominion. Most of us are stuck in the de facto. We have been educated with MK Ultra since 1947, when the Attorneys Treaty, the United Nations, and other infringements were started, thus moving the seat of power to the United States of Washington, District of Columbia, Inc., in some form of de facto since 1861. A double down in 1913 and again in 1933 with Project Paperclip, the Nazis, jihadists, socialists, communists, et al. Are not Article 4, Section 4, not the McCarran-Walters Act of 1952 and 65, and not the constitutional Republican form of government. Did you get 5 years of education in the Constitution starting no later than the 8th grade? You and we all know that ORS has been long ignored. What we do have is not good, while the current form of the Salem oligarchy continues to run its course. It has failed and we are no longer deceived. There are over 200 United Nations members, most of whom are monarchs or presidents of their countries for life. We have the 1871 de facto version going on here in the United States right now. Currently, we have the DJT version of martial law, Libre Code FEMA. It is just changing the de facto again. They do not want to go anywhere near Jural, except us on Oregon. Jural means by right, by law. by all of our unalienable rights guaranteed by our constitutions circa 1859. This is from Bouvier's Law Dictionary, page 701, volume 1, 6th edition, 1856. Black's Law Dictionary changed the definition of jure to align with the de facto. Facto means in fact, in contradiction to the lawfulness of the thing, end quote. From Bouvier's Law Dictionary, page 517, volume 1, 6th edition, 1856. Here, as well, Black's changed the definition to align with the de facto. De facto, in Black's dictionary, is illegal and illegitimate. That's a quote. Page 416, volume 1, 6th edition. Jure in Black's, quote, is lawful and constitutional, end quote. The fact that neither definition exists in Bouvier's Law Dictionary, 6th edition, 1856, indicates that the de facto government didn't come into existence until circa 1871. Our de facto on Oregon is a fact of fraud, as evident by Article 7 amended in our Oregon Constitution, circa 1910. The entire Salem oligarchy continued with Kate Brown acting as governor, who was responsible for requesting the FBI and was in direct control of the Oregon State Police. To discourage discovery of their dirty deals regarding Uranium One and the BLM land grab water rights issue, they murdered Lavoie, then buried the tragic loss of a man standing with fellow ranchers on his way to negotiate a peaceful resolution. The Salem legislature exonerated the killers and shooters in the Oregon State Police. Thereafter, they shut us out of our legislature's proceedings. What ensued on January 21, 2021, was one of a series of due process violations. Tina Kotek was Speaker of the House at the time. She has no honor and may not hold a position of trust. The judiciary on Oregon, the Supreme Court, and their counsel acquiesced and defaulted twice. Article 7 amended is fraud upon the people. Look up Wally Carson from decades past. The Constitution Party. Milt Mitchick, an Oregonian who spent much time researching and traveling Oregon to create the important revealing booklet Vultures, republished at our website, www.orsja.org. This is where you can also find our Oregon de jure Journal newspapers, Bouvier's Dictionary, 6th edition, our instruments, documents that are signed, sealed, stamped, witnessed with proof of service, and published. You can also find us on 3CTV Weekly, YouTube, and Brighteon. Read, learn, respond. Thank you for listening.
Anthony Devine. Sheriff, one and all, the ball is in your court. We kicked it into your jurisdiction, which is separate from ours. Alas, it really is one team, you and us. It is, or rather should be, one jurisdiction. Your training, probably from childhood, has been to join the realm of the corporate jurisdiction, which is the entity that pays you to do what you do. You can join our team, that of the people, with a simple turn of mind switch. A tool to assist in this process is to consider taking a proper oath to the proper constitution with this original jurisdiction and with the laws of nature and of our nature's God, as stated in the Constitution. The last several months, we have posted and made publicly available what we consider a proper oath for the persons in our governance. Sheriffs are our first effort at insisting on a proper oath, but it is the sheriffs who are in their county position to protect and defend the people from ticketing or sending people to the illegitimate amended Article 7 courts that should not be. From governance, overreach, and taxation that takes seniors' equity their forever home and all they possess by enforcing conviction. It's like a switch in the mind and one's understanding. The switch is the recognition of one's allegiance to life and that which is God-given. Rather than criminalizing living God-made beings for a dead corporate entity, our shares are our first protection against governance overreach. Taking a solemn oath is needed for there to be remedy in our authoritative system of governance. Once a sheriff can make the switch, can see themselves as one with the people rather than a corporate entity meant to enforce our compliance to the bidding of the state, there will be greater freedom, cooperation, and peace. Let it be so. I yield.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car. And he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.